Good evening. Hi. Good evening, everyone. My name is Fatin Jarara. I'm with Al-Awda NY, the Palestine Right to Return Coalition. And we are here today because we recognize that there was a need and an urgency in having this Know Your Rights training that is going to be reflecting on the increased repression that Palestinians, Arabs, Muslims, people of color, allies, comrades have been facing in the past couple of weeks, and the increased repression, the increased suppression of our voices. We've seen recently, for example, an introduction by, I think, a councilwoman who is actually in my neighborhood who wants to introduce a measure to criminalize blocking roads and bridges and tunnels to make it as a domestic act of terrorism. And we've seen that things that have in the past sort of been okay by the police or not very clearly or strictly enforced have now become more criminalized and have resulted in people who, thought that they were just going to a protest, potentially risking arrest, even though we have the right to assemble, we have the right to rally, and we have the right to organize. And so we reached out to Mo, who has kindly made themselves available to host this Know Your Rights training. So Mo is a attorney and a criminal defense worker who specifically targets those who are arrested during justice struggles, representation of witness before federal grand juries, and advocacy for those seeking gender affirming and other necessary but often withheld health care while in prison. And Mo is an educator, abolitionist, and criminal defense attorney serving overlapping communities of activists, queer folks, and prisoners. And many of us in the community and in the movement for Palestine have had the pleasure to work with Mo, whether through this kind of work or have had to be represented by Mo. So we're really happy that Mo can make themselves available for us to have this conversation. And just for the record, this webinar is being recorded and will be uploaded on Al-Awda New York's YouTube channel. So without further ado, go ahead, Mo, do your thing.
Good evening. Hi, everybody. Thank you, Al-Awda, for organizing this. I'm always happy to do a Know Your Rights training. Thank you to everyone who has come to this Know Your Rights training. I hope that it leaves you feeling courageous and ready to stand up. I will be using slides that I've been given permission by the artists to use, and I just want to give all of those artists a shout out before I start. Naomi Frank, Shalene Rodriguez, Ronald Wimberly, my beloved friend, and Tana Tucker all contributed art to this slideshow. I'm Mo. I have represented thousands of protesters at this point, both in New York and elsewhere in the country, particularly at Standing Rock during the No DAPL struggles. I have a lot of experience dealing with state repression, and I am pleased to be here tonight to talk to you about how to remain resilient in the face of state repression. This is all of my information. So you can reach me on Signal. That's my direct line. We also have a hotline. The National Lawyers Guild put together a hotline during the George Floyd uprisings. And I'll talk to you a little bit about that later, but it's a hotline to call if you have unwanted contact with federal law enforcement. If you call that number, you can have a privileged consult with an attorney about your rights, risks, and responsibilities anywhere in the country, and we will try to refer you to the most appropriate legal resources in your part of the country. You can also email me at moatlaw@protonmail.com. So I'm going to talk to you tonight about how to be resilient and continue your solidarity work and your activism in the face of state repression. What is state repression? State repression is the use of the state's power to target, harass, and punish people and undermine any activities, ideas, people, or groups perceived as being a threat to state power. The state's perception of threat can be a result of actual conduct that people are actually engaging in, whether or not that conduct is lawful, and even if that conduct is protected by the Constitution. The state's perception of something being a threat can also be based on nothing more than an individual or group's perceived identity, which is to say, you don't have to be doing anything effective, you don't have to be doing anything illegal, and you don't have to be doing anything at all to be subject to state repression. So some examples are when police use mass arrest as a form of crowd control at protests, that's state repression. When the FBI in the 1960s and 70s sent letters to different chapters of the Black Panther Party to try to stir up conflict between them, that was state repression. Stop and frisk, driving while Black and walking while trans, where law enforcement has the ability to selectively invoke laws in order to target specific identity groups, is an example of state repression. The selective investigation and monitoring of political groups and people perceived to have political identities is certainly a form of state repression that many of the people at this training are likely familiar with. So one thing about state repression, all the examples that I just gave are visible, right? They're legible to us. We know they're happening. But state repression, surveillance, monitoring, collecting information, social mapping, phone tapping, those kinds of things are happening all the time, whether or not we can see them. Now, I'm not telling you this to frighten you. I just want us to have an understanding that there is a lot going on all the time, whether or not we can see it. There is nothing that I can tell you that will eliminate state repression, that will eliminate the harm that comes from state repression or the risk of state repression. But what I can do tonight is talk to you about your rights, your risks, your responsibilities with respect to the state. And I can give you some tools and strategies that can mitigate some of the damage that you might face as a result of state repression. So let me make clear some assumptions, okay? Just assumptions about my approach to this training. The law is a different thing from law enforcement practice. And law enforcement practice is very different from what might happen in a courtroom and what might happen either in law enforcement practice or in a courtroom is often unrelated to or even incompatible with a well-developed vision of justice. The role of the police is to maintain public order. And of course, each individual or group of officers will maintain their particular vision of public order. And that vision of public order may or may not be related to your vision of public order, and it may or may not be related to the law. So while you may be absolutely correct in your assessment of the justice of any particular method of policing, the only party who has any authority to determine the legality of police conduct is a judge. And that judge will not be available to make that determination in real time during any kind of interaction with law enforcement. This is but one of many reasons that it is not particularly useful to argue with police officers. Your innocence will not protect you. What I mean by that is, as I said, you don't necessarily have to be doing anything unlawful or anything at all to be targeted for state repression. That doesn't mean that you roll over and you stay inside under the bed all day. What it means is that you build your skills and you stand in community with other people and you learn strategies and you learn your rights and you do things like we're doing right now. as I said, there is not a one-to-one correlation between the law and how law is enforced. And this is particularly true around the policing of criminalized identities. That is where identity, as opposed to conduct, is policed and punished. And criminalized behavior, where police and prosecutors might target behavior that is lawful, but that is viewed as undesirable or immoral. So I am not in any manner suggesting that you change your behavior or that you sit out protests. I am suggesting that you go into those protests and that you go into your free speech activities and assembly activities well prepared with the best possible tools at your disposal to weather any repression that you may encounter. So the First Amendment, the very First Amendment, protects your rights to political and religious belief, association, assembly, and expression. That is to say, the First Amendment says that the state is not supposed to make it illegal for you to think or believe things, or to associate or assemble with other like-minded people. But the First Amendment does not immunize you from prosecution for otherwise unlawful behavior. And what I mean by that is that illegal behavior is still illegal, even if it is motivated by beliefs that are themselves protected. So if you throw a rock through a window and it's a politically motivated rock throwing, you can still be arrested and charged with criminal mischief, even if you were very sincerely were motivated by your political beliefs. I think one thing that I'd like to encourage people to do is consider the costs and benefits of different courses of action. And I am absolutely not here to tell you how to live your life. But I do want to make sure that anyone who is engaged in dissidence or what we would call protest behavior, however garden variety it is, understands what the possible consequences are, what are reasonable consequences, what might be unexpected consequences, so that you can make informed decisions. And I guess that's all I'll say about that. As I said, state repression exists all the time, even when we can't see it. And that's really scary. And in fact, one of the most powerful tools at the state's disposal is fear. Fear can act as a prior restraint on speech. It can lead to self-censorship. It can lead to people being unwilling to stand up for what they believe in. It can prevent whole social movements from getting off the ground. But the solution to these efforts to frighten you into silence isn't hiding, it's courage. And also being prepared to have good security practices. Security is a set of practices, not a set of tools. What I mean by that is I think there are a lot of people now who are using encryption, which is great, and you absolutely should. But I think sometimes people forget that not all surveillance is digital. So you should very much familiarize yourselves with the list of resources here, because encryption does allow you to have private conversations, which you're allowed to have. You have a right to privacy. Privacy is not code for doing crimes. We have doors on our bathrooms and curtains on our windows, and you're allowed to have conversations about things to which the state is not entitled. So it is good to use these encryption tools and to use these technologies. And it is also good to be circumspect about the kinds of things that you are saying and the kinds of jokes that you may be making and to whom you may be making those jokes. And if you are at a meeting and someone you've never met suggests involving fire or incendiaries or explosives in your social movement strategy, maybe don't talk to that person anymore. Okay. Your right to film police is protected by the First Amendment. However, as with all law, much hinges on the word reasonable. You are allowed to film the police from within a reasonable distance. But it is the police who get to define what distance is reasonable. So if you are filming the police and they ask you to back up, I would consider backing up while also saying, I am backing up. Because if nothing else, your statement that you are backing up will be captured on the video that you are taking. Filming police in the public discharge of their duties is protected by the First Amendment. Interfering with the discharge of those duties is not. And again, it is the police who, in the moment, get to decide whether or not you are interfering with their duties. One of the things that I will teach you to do is to invoke your rights using legally effective language. And when I say invoke your rights, I'm talking about the rights that are guaranteed to you in the Bill of Rights, right? Your First Amendment rights, your Fourth Amendment right against unwarranted searches and seizures, meaning searches of yourself and your things, and seizures, meaning arrests. Your right against compelled self-incrimination, which is your Fifth Amendment right. It's the one that we often hear referred to as your right to remain silent, and your Sixth Amendment right to counsel, to an attorney, okay? I'm going to teach you how to invoke those rights with specific phrases. It is very useful to do this for several reasons. One reason is that it puts the police on notice that you and your community know what your rights are. Another very important reason is that if your rights are violated, having invoked them makes it much easier for someone like me to vindicate that violation of rights later in court, whether that means getting some kind of settlement from the NYPD, or whether that means effectively defending against a criminal charge. You need to understand that if you do not invoke your rights, that is considered consent to whatever the police do. So, or they aren't just allowed to hit you if you don't say, I don't consent to you hitting me. But in terms of searches and arrests and your right not to speak to police, you need to invoke those rights in order for them to become effective. There is nothing that I can tell you that will prevent the police from violating your rights. These are not, in fact, magic words. Once you invoke your rights, you are doing something, you are making a statement that has meaning later on in court. But saying that you don't consent to a search does nothing to actually constrain the behavior of police. So please do understand that you're not necessarily invoking your rights in order to affect a particular outcome during an interaction with law enforcement. I do want to encourage everyone to always do what feels safest. It is useful to invoke your rights. I think it's very important. I want to encourage you to learn how to do it and to do it if you need to. But I also trust everybody to know what might put them in unnecessary danger. So you should always make your own decisions and do what feels safest. So if you are stopped by the police, you can say, am I free to go? Or am I being detained? if you are being detained, they have to have a reason. They have to have basically a real reason to detain you. And so if they say that you're being detained, ask why. So if you say, am I free to go? And they say yes, confirm that you're free to go and bounce. And if you say, am I free to go? And they say no, then ask if you are being detained. And if they say yes, then ask why and pay attention to the answer. And if they say you're not being detained, then ask whether you're free to go. So I want everyone at home joining us this evening to read these out loud to yourself. Say it along with me. I'm going to say it twice. I want to help you build the muscle memory. If you have a pen and paper handy, please write these down. I think it's very useful to try to remind yourself what these phrases are. Because if you are in fact having an interaction with law enforcement, it's very likely that you are not going to remember exactly what the words are that you're supposed to say. So I want you to practice so it becomes second nature. Okay, so am I free to go or am I being detained? Am I free to go or am I being detained? And if they say you're being detained, go ahead and ask them why. Now they may say something totally off the wall. They might say nothing. They might say because you fit the description. Again, whatever it is they say, try to remember it. And then if you do end up being criminally charged later, or if you do end up having a civil rights lawsuit later, you can communicate whatever it was to your attorney. Now, in some states, it is its own criminal offense to refuse to identify yourself to a police officer. These are the states where that is the case. These are called stop and identify states. Even in places where it is not a crime to refuse to identify yourself, it can be much more expedient if you do show your ID to law enforcement. Because at least in New York, if you refuse to identify yourself and they do have cause to detain you, then they can take you in and hold you for much longer than they otherwise would in order to confirm or verify your identity. And I am of the opinion that the less time you spend in the company of law enforcement, the safer you are. So giving them your ID can be, as I said, expedient. So if you are stopped and detained, they can ask you for your ID. And they also might pat you down over your clothes to check for weapons if they have a reasonable suspicion that you are a threat to them. Again, much hinges on this one word, reasonable, and who gets to define it. So, if they do try to search you or instruct you to turn out your pockets, you can say, I do not consent to this search. Say it loud and clear, because again, if you say nothing, that is considered consent to the search. If you invoke your Fourth Amendment right against unwarranted searches, and they find something that they would like to use as evidence against you during that search, a judge can find that the search was illegal and exclude any evidence that they have uncovered. Please bear in mind that almost anything is evidence. I have had people arrested or searched where a little scrap of paper with an address on it was found in my client's pocket. And the prosecutors and police were absolutely convinced that this was a location of a store that was going to be looted. It wasn't. It was just their friend's address. But it was impossible. We were unable to convince this prosecutor that this little piece of paper was not some smoking gun. So understand, very much in the way that they say anything you say can and will be used against you. Anything that you have on your person can and will be used against you. It is very, very much the case that law enforcement will find a way to interpret even the most innocuous things as somehow sinister. So when I say invoke your right not to be searched, this isn't a situation where your innocence actually protects you. This is not a situation where because you have nothing to hide, you have nothing to lose. The fact that you aren't holding fireworks and drugs doesn't mean that whatever you do have in your pockets isn't going to be interpreted in the least generous possible way. If you are arrested, please understand that you will be searched incident to that arrest. It can still be useful to say that you don't consent to a search, but you will be. Now, if you are arrested, you do have one right that is extremely important, and that if it's properly invoked, you actually do have control over whether or not your rights can be violated in this regard. Because if you say to a police officer, I do not consent to this search, they can still go through your pockets. But if you say to a police officer, I am going to remain silent and I want to speak with my lawyer, and then you remain silent, they can't actually compel you to speak to them or answer their questions. I get this question a lot, so I'm going to answer it preemptively. When you are arrested, police officers do not typically read you your rights. That only happens on television. I am reading you your rights right now. So you have been educated, and if you are arrested, please don't be alarmed that they aren't reading you your rights. The point at which they might read you your rights or advise you of your rights is if they take you into a separate place and start questioning you. At that point, they probably will advise you of your rights against compelled self-incrimination. That is your right not to answer their questions. But that is not the only time that they're going to be gathering information. So it can be pretty important to say, I'm going to remain silent and I want to speak to a lawyer, and then to remain silent, because it doesn't work if you then start talking to them. As I said, anything you say can and very much will be used against you. And that is everything from trying to convince the police of the righteousness of your cause, to telling the police about what happened in the moments leading up to your arrest, to telling the police who your favorite baseball team is and what you had for breakfast. Anything you say can and will be used against you. And that is not just anything that you say directly to police. It's anything you say to journalists or to Facebook or social media or even your mom. The only people who share a legal privilege are your lawyer and your therapist and your doctor. So please, please understand that it is dangerous to speak to police officers. It's dangerous for yourself and it's dangerous for your friends. And it can be dangerous to people you don't even know to speak to police officers, and you have absolutely no obligation to do so. Your right not to answer police questions and not to talk to police is protected by the Constitution, and it's protected for a reason. Now, I want to talk to you again briefly about the expedient here, which is the police are going to, if you are arrested, police are going to ask you questions about who you are and where you live and your social security number and things like that. And it's okay to answer those questions. But truly, any information that they get very much can be used against you. The other exception here that I want to really make clear is if you or someone else who has been arrested needs advocacy for their human dignity, for their medical care, because they need water, please, please advocate for everybody's welfare. But once you've gotten what you need, you can re-invoke your rights. And be aware that the jails are monitored and that the police are in fact listening, and that sometimes they put random people in the cell with you who engage you in conversation and ask you lots of questions, and express a lot of interest in your social movement. And those people may or may not be acting in good faith and may or may not be reporting everything you say right back to the police. So we're going to practice this. I like to encourage people to practice this every day. Again, to build the muscle memory so that you remember what to say in the event that you are arrested or questioned by police. I am going to remain silent and I want to speak to my lawyer. I'm going to say it again. I am going to remain silent and I want to speak to my lawyer. Now, please understand, the police may behave as though this is deeply insulting. They may behave as though it's unusual. They may try to convince you that it is evidence of guilt. It absolutely is not. There is never, ever a compelling reason to speak to police or answer their questions before you speak to an attorney, and you absolutely have the right to do that. I want to remind you that anything you say can and very much will be used against you. If you are already in custody, there is nothing that you can say that will speed the process. There is nothing that you can say that will get the police to say, oh, we accidentally arrested you. You are free to go. You cannot talk yourself out of custody, but you very much can talk yourself into a conviction. And we would prefer you not. And I suspect you would also prefer that you not. So again, go ahead and just say, respectfully, I'm going to remain silent and I want to speak to my lawyer. Okay, so I referred earlier to a hotline that the National Lawyers Guild developed, and I think there are a few different hotlines. I know CUNY Clear has a very good hotline that does similar work. This one was developed, as I said, during the Floyd uprisings, for folks to call in the event that they have an encounter with federal law enforcement, because we were seeing a lot of federal activity, especially around protest activity that we would normally have understood to be really stuff that would typically be dealt with by the individual states. And it was becoming, the federal government was asserting jurisdiction over it or was investigating it in a way that wasn't sufficiently unusual and sufficiently widespread that we created a hotline. The phone number to that hotline is 212-679-6018. This is the hotline to call if federal agents call you or visit your home or work, or if you or someone close to you is arrested by federal agents, or if you are served a federal grand jury subpoena. This is not the right hotline to call about state matters, whistleblower matters, or having been injured by police at a protest, although if you do call with those issues, we will still try to refer you to the appropriate resources. If you call this hotline, you can have a privileged conversation about your rights and responsibilities, and we will do our very best to refer you to the best and most appropriate legal resources wherever you happen to be. So, one of the most common ways that federal repression happens in a community is just via them coming and knocking on your door or calling you up. Now, federal agents will approach people to see if those people will speak to them voluntarily. They are very often doing this because they do not have any actual reason to believe that any federal crime has happened. And therefore, they do not have a warrant that would allow them to access your home or place you under arrest. That means they don't have the information that would allow them to ask a magistrate judge to give them a warrant. Guess how they go about getting that information? They get it because people agree to speak to them voluntarily. And again, they can get information that allows them to get a warrant, whether or not anyone's actually doing anything illegal, and whether or not any crime is happening. The way law enforcement gathers that information that they'll use to further intrude into your movements and communities is by convincing people to speak with them voluntarily. Again, your rights to belief, association, and political activity are protected by the very First Amendment. That does not mean that it is safe to share your ideas, address book, or political activities with law enforcement. Again, because of the sinister cast that is applied to all things that law enforcement is looking at, even if there has been no illegal activity, it can be very dangerous to speak to law enforcement. And they simply are not entitled to information that is protected by the First Amendment. And in fact, they're not entitled to information that you don't want to give them. So, please also know that the Fourth Amendment, which is the amendment you invoke by saying, I do not consent to a search, the Fourth Amendment also protects you against warrantless entry into your home. And so if law enforcement does knock on your door and asks to come in, ask if they have a warrant. If they do have a warrant, ask them to slide it under the door. A warrant to search your home, ask them to slide it under the door. And if they do not, then you don't need to let them in, and it can be very dangerous to do so. Instead of letting them in and speaking to them, the best way to make sure that they don't end up with all of the information they need to further intrude into your community is by declining to speak to them and directing them to your attorney. You do this by saying, I am represented by counsel. Leave your name and number, and I will have them call you. If you are not represented by counsel, you can just say to them, leave me your name and number, and a lawyer will call you. Once they know you're represented by counsel, they can't approach you directly. They need to speak to your lawyer. And your lawyer can then act as a shield and can gather information and figure out if the inquiry is actually very serious or if they're just kind of poking around and casting a wide net, which is very often what they're doing. Once they know that you are represented by an attorney, it is often not worth their time to follow up at all. And so very often when I have clients who are visited by federal agents and I call and let the agents know that my clients are represented, that's the last we ever hear of it. In the event that there is more going on, you definitely want to have an attorney to have your back. I talked to you a minute ago about warrants. I want to add to that if they do have a warrant, take a look at it, ask them to slide it under the door, and read it out loud so that they know that you know what they are there to look for. A warrant, a search warrant, must describe specifically what they are allowed to look for and where. And so if they're looking for a Volkswagen, it makes sense for them to look in your garage, and it does not make sense for them to look in your pocket. And if they don't have a warrant, you don't have to let them in. Please also be aware it is a crime to lie to certain federal law enforcement or to certain law enforcement, which means that the safest thing to do is not to speak to them. It is totally fine not to speak to cops. It is totally normal not to speak to federal agents. They are very, very used to people telling them to talk to their attorneys. If you notice on TV, rich people lawyer up immediately. There is no reason that you should not also, and there are many, many very good reasons for you to let the police know or to let federal agents know that you are represented and that your lawyer will be contacting them. But in order for that to happen, do remember to get their name and number. I had put in the chat a document that you can fill out. And if you want to, you can put the number to the hotline on it. And you can just tape that right to the back of your door so that if police or law enforcement agents of some kind do knock on your door, you don't have to try to remember what it is that you're supposed to say to them. You can just read it off of the sign. And you can also feel very free to call the hotline or to call my number in real time. So let's practice this. I am represented by counsel. Leave your name and number, and my lawyer will call you. And if you're anxious about saying that, if you do not have an attorney, you can say, please leave your name and number, and an attorney will call you. Okay? And you don't have to tell them which attorney. You can just keep repeating, leave your name and number, an attorney will call you. And again, they are used to this and hopefully will not give you too much of a hard time about it. But if they don't have a warrant, you don't need to keep talking to them or let them into your house. So arrest and prosecution are not the only ways in which encounters with law enforcement can disrupt social movements. Simply having an open investigation or federal agents running around knocking on doors can itself be disruptive, can cause conflict and friction, and can distract from the actual work or diminish the effectiveness of the work. If and when there are prosecutions, it can mean that fewer people remain available to do what has now become very risky, high stakes work. It means that much needed resources get funneled to legal support rather than direct service. So I can't stress enough that not speaking to law enforcement, not answering their questions, and invoking your right to counsel are fundamental, and the sort of universal community invocation of those rights is critical to mitigating or diminishing the degree to which law enforcement can disrupt your work. So again, invoking your right to counsel, not answering questions, these are not only critical, but legally effective and often spell the end of any further investigation that involves you directly. Now, that does not mean that it is the end of any further investigation of your community. So this is why universal community solidarity in invoking those rights is key. Again, the fact that you have nothing to hide does not mean that the state is entitled to information. And you need to be prepared for the state to interpret any information that they do acquire as though it is in some way sinister, whether or not it actually is. So if you invoke your rights and you say, leave your name and number and my attorney will call you, that's often the end. But what if it isn't? Well, there's a couple of things that can happen. One thing that might happen is that they could issue an arrest warrant. And if that happens, you need a criminal defense attorney who has experience and expertise in defending against politically motivated prosecutions. The other thing, remember, we're now talking about federal criminal investigations, okay? The other thing that rarely but occasionally happens is that an individual might be issued what is called a federal grand jury subpoena. So, first of all, subpoena just means summons. There are subpoenas of many kinds that happen all the time and aren't that big a deal. If you get any subpoena and you are curious about it or worried about it, feel free to call me at 212-679-2811 and we can figure out what it is. A subpoena to a federal grand jury is a notice directing you to appear as a witness to provide documents or to answer questions before a federal grand jury. Okay, what's a federal grand jury? It is the process by which a federal prosecutor presents evidence to a group of 18 to 24 people who've been called for grand jury duty, just like regular jury duty. And that group of people determines whether there has been a federal offense and gives permission for the prosecutor, or very rarely denies permission for the prosecutor, to bring charges against somebody. So I want to be very clear that as far as I am concerned, the entire criminal legal system is a political system. But not every federal grand jury is explicitly politically motivated. Not every federal grand jury would be credibly characterized as a political abuse of prosecutorial power. However, where federal grand juries are politically motivated, there are some special characteristics of a federal grand jury that make them extremely powerful tools for disrupting movements while also insulating them from accountability. Why? Because federal grand juries are so weird and bad. Unlike literally every other proceeding in the US legal system, grand juries happen in secret. This is ostensibly supposed to protect the person who's being accused of a crime, but what it actually functions to do is undermine transparency. Now, I'm going to say this and it's going to become important in a minute. There is one important exception to that secrecy requirement, which is the witness, that is the person who gets the grand jury subpoena, is not bound by that secrecy requirement unless there's a special court order. So the witness themselves is allowed to talk about the fact that they have been given a subpoena, and they're also allowed to talk about what happens if they go into the grand jury and are asked questions. They're allowed to tell the public what happened. So another thing that's unique about federal grand juries is that unlike all criminal proceedings, there is no adversarial element. There's no defense attorney. There's no judge. And because it's secret, there's no public. So the only person in the grand jury besides the grand jurors is the prosecutor. And that person gets to present the case to the grand jurors, which means they control the narrative. They get to control what evidence to include and what evidence to leave out. And that is why nearly 100% of cases that get presented to a federal grand jury end with somebody being indicted for an offense. But somehow federal prosecutors almost never indict police officers. So also, unlike a trial jury where all the prospective jurors only have to sit for a day or at most a few weeks, federal grand juries can meet up to twice a week for 18 months. And that means that grand jurors, the people who get called for grand jury duty and sit on the grand jury, are very often people who are of an age and class that has enabled them to be retired. Unlike a trial jury where jurors get questioned about their histories and ideologies by a prosecutor, a defense attorney, and a judge, federal grand jurors don't get screened for bias at all. And unlike any other court proceeding where there are rules of evidence that exclude hearsay, overly prejudicial information, irrelevant information, and unlawfully obtained information, there are almost no rules of evidence in a federal grand jury. So remember that I keep telling you that you have no obligation to cooperate with law enforcement or answer their questions. Unlike when you are being questioned by law enforcement, participation in the grand jury is compulsory, meaning that consequences can be imposed if you refuse to participate. Now, there are many ways to challenge a grand jury subpoena. I'm not going to go into all of them, but I want to make very clear, nobody but you, nobody but the person who is given a grand jury subpoena can decide whether or not they want to cooperate with that subpoena. It's not a question your lawyer can answer. It's not a question your best friend can answer. It is a purely personal decision. This is something that you, to whatever extent you want to, can certainly contemplate ahead of time with your community. And I would recommend that you do think about what you might want to do to provide support in the event that somebody did get a grand jury subpoena. You know, what kinds of agreements would you want to make about whether or not people can be expected to cooperate with that grand jury or not? Right, you could do things like set aside money for legal expenses and social support. You can set aside that funds for people who end up having consequences imposed upon them because they refused to cooperate with a federal grand jury, or for people who had consequences imposed upon them because somebody else cooperated with a federal grand jury. Now, the consequences of cooperation do not simply include answering questions and disclosing information about your community, or disclosing information about actual criminal conduct. It often involves disclosing information about your community, about people and movements that is entirely lawful, but that could be used to justify further state surveillance, further monitoring, or to engender conflict within that community. It can mean giving the state information that is entirely unrelated to illegal behavior, but is socially compromising. It can mean giving the state information that isn't any of the state's business. It can mean causing internal conflict in movements, chilling people's commitments to movements or willingness to participate in them due to the fear that they will come to the attention of the state. It can and often does mean that the witness themselves, the person who does disclose all this information, that person themselves often ends up being subject to federal prosecution, sometimes for traditional civil disobedience activities that people did not necessarily anticipate would constitute federal offenses. So again, I don't have time here, and you probably would not be particularly interested in hearing all of the legal grounds for challenging the validity of a grand jury subpoena, but they are legion. We litigate these issues vigorously, and the truth is that while we rarely win that litigation, it is really important to go through that process. Whether or not you intend to ultimately cooperate with the grand jury, because there are legitimate legal defenses to basically any grand jury subpoena that deserve to be fully explored before you just agree to cooperate. Ultimately, a validly issued subpoena means that you must answer questions or face certain consequences for refusing to answer those questions, and those consequences can include going to jail. There are a lot of really negative possible consequences to agreeing to cooperate with a federal grand jury, and those consequences can include going to jail. If you decline to give testimony pursuant to a validly issued grand jury subpoena, a judge may find you in what is called civil contempt of court and can put you in prison until you decide to cooperate. in a civil proceeding, which does not involve all of the various procedural protections that are associated with criminal due process, it is not permissible for a judge to impose punishment. They can confine you in prison, but it is not for punishment. It is for the purposes only of coercing you to comply with their order to testify before the grand jury. So, if you decide to cooperate, you will be released from jail, from prison. And if you don't decide to cooperate, you will stay in prison until the grand jury expires 18 months after it was convened. And if the grand jury expires before you have spent 18 months in prison, the prosecutor can reconvene it and keep you in for the remainder of the 18 months. But after 18 months, they must let you out. Or, and this is the important part, the most effective legal strategy has been to convince the judge that you cannot be coerced and that you will never be convinced to cooperate. Because remember, the only permissible reason that they can confine you is to coerce your cooperation. And if the confinement is not exerting any coercive impact on you, then that confinement will have impermissibly trespassed from being merely coercive to being only punitive, which is unconstitutional in the absence of a criminal proceeding, right? Because again, this is a civil proceeding. So if you can show them that you are incoercible, the judge will have to release you. There is another kind of contempt of court, which is criminal contempt of court, where a witness who refuses to cooperate, that is called a recalcitrant witness, can be criminally indicted for that refusal and given a full criminal trial. And in that situation, the judge may impose punitive sanctions. This is very unusual, but most people who get a federal grand jury subpoena are reasonably terrified by the prospect because there is no statutory maximum sentence for criminal contempt of court. Now, again, it is highly unusual to see somebody indicted for criminal contempt, and sentences that don't have a statutory maximum term are calculated by comparing them to similar offenses. So most people who are charged with criminal contempt end up with sentences ranging from about 3 months to 3 years. Some sentences range as high as 10, and a notable exception and an important exception to the generally lenient sentences imposed upon recalcitrant witnesses are the sentences that were handed out to witnesses who refused to give testimony to grand juries that were investigating so-called Muslim extremists post 9/11. So, one of the reasons that grand jury subpoenas are such a powerful tool is that the government is basically always going to get something they want. Either they're going to get information they want, which has the added consequence of disrupting a community via fear, indictments, and convictions, or they can subpoena somebody that they know will not cooperate, coerce their contempt of court, and exact a real cost from that witness, while also draining the community of resources and energy and working to distract from the actual movement work. So, for any community experiencing grand jury repression, social solidarity, public education, and media work are critical. Putting together not only a legal team, but a robust support team is crucial. And all over this country, there are legal workers and lawyers and people who have provided and also received this kind of support. And they are very generous with their time, energy, and expertise. Again, I do not believe that this is very likely to be something that you have to deal with, But if this is something that you have to deal with, you can feel very free to call me or to call the hotline, and we will figure out how to refer you to appropriate supports. So, state repression can happen via on-the-ground policing, surveillance, and intimidation. It can happen via undercover operations like COINTELPRO, where agents intentionally create conflict inside our communities. And it can happen via overt legal actions like investigations and prosecutions, entrapment, and undercover operations. Sometimes it involves militarized violence. All of these types of repression function to drain our resources and function to drain our energy, distract from our goals and messages, test our commitments, and sow fear, mistrust, confusion, and discord. And in this way, the state can even benefit from the impacts of our own interpersonal disagreements. And often, interpersonal disagreements end up being widely believed to be the result of state repression, whether or not they are, which causes even further disruption. But it is possible to support each other, to endure the consequences of resistance, to endure the consequences of cooperation with law enforcement. And in addition to legal strategies and social support and community agreements, patience and fortitude and optimism are truly materially useful tools for individual and community resilience in the face of state repression. There are lawyers and legal workers and therapists and many, many people who have already been through this crucible. We have good tools for legal defense and for social solidarity and for protective security practices. We are resourceful. We are expert at standing up for each other and acting with principle. We have strength and courage, and if all else fails, you have my number. Thank you so much. If there are questions, I guess I'll look in the chat. Okay. Thank you so much for having me. And if people have further questions, I'm happy to answer them one-on-one. You can email me, you can text me on Signal, and I am happy to make myself available for those conversations.
Thank you so much, Mo, for your time and for everything that you've done. I also want to give a shout out to Awali, who's in the background, not as a panelist, but as somebody who's helping manage this webinar. Awali is also with Al-Awda NY, New Jersey. We're with Al-Awda NY, New Jersey, and the Palestinian Assembly for Liberation. And we want to also say power to the resistance and power to the disruptors, power to the protesters, power to the people who met Genocide Joe this afternoon as he was very unwelcome in New York. And please stay in touch. We will be posting the webinar on YouTube without the Q&A portion. But if you have any questions, you're more than welcome to send us a message. You should have our email addresses, and we'll send you a follow-up after this. And you should also have Mo's contact information.
Thank you.
Without further ado, we will be ending this webinar. Thank you for the comments as well. I hope you understand we disabled chats because there's been a lot of hacking attempts and this kind of things, and spamming attempts. So thank you so much for everything, everybody. Thank you.